these testing times, people are willing to share and learn knowledge. And once you have a speaker like Honorable Justice Dr. Shalini Phansalkar Joshi, who has already been on a platform, and her webinars are quite popular because of the immense knowledge which she gives in a capsule form. Consequently, when we approached the National Law University, Dr. B.R. Ambedkar from Sonipat, the Vice Chancellor, who herself is an erudite speaker with immense knowledge, and her passion that the knowledge should actually disseminate down to the society from students to all professionals. She immediately acceded on a topic which we all talk, especially in the field of law and professionals who want to get themselves assimilated with the subjects. And as we all know that the topics of maintenance on children's rights and different perspective of laws related to that, Justice Shalini Phansalkar Joshi is a known speaker not only out here in judicial academies, and her different webinars and seminars are immensely popular on that. And the topic for today is Juvenile Justice Act in context of children in conflict with law. And amongst us, we have the Dr. Professor Vinay Kapoor Mehra, the Vice Chancellor of the Dr. B.R. Ambedkar National Law University, Sonipat. And it gives us a pleasure to the effect that we have done quite large number of webinars for the purposes of knowledge sharing. And under the aegis of Dr. Vinay Kapoor Mehra, the National Law University is creating its own niche within the society. National law universities, we know that they are popular, those who want to pursue law. One of their aims is to get admission in the National Law University because it has its own facets. We will request Professor Dr. Vinay Kapoor Mehra to give the welcome address. She herself has a quite passionate about the family law subjects and the children law. And as such, we requested. Ma'am, kindly unmute yourself. Dr. Vinay Kapoor Mehra.
Thank you. So we are today together again. Topic which will be by Justice Shalini ji. So much impressed from her biodata that a very small place.
Ma'am, I'll just check. Probably it's not audible. It's audible to you from Dr. Vinay Mehra? Yeah. Ma'am, you will have to unmute yourself. Vinay Kapoor. Vinay ma'am, I think she has a issue with the net. I'll ask. We have Amit Guleria from the university. She can. We will unmute him to apprise the fact. Ma'am, aage unmute her. Ma'am, till ma'am joins, we have Amit Guleria from the university itself. He will apprise the facts. Meanwhile, I will connect to Ma'am Vinay Kapoor. Amit?
Yeah, sir, I'm here.
Yeah.
Sir, is it audible?
Yeah.
Okay, fine. So I really apologize due to some technical glitches. Might be ma'am is not get connected. So on behalf of Professor Dr. Vinay Kapoor Mehra ji, the Honorable Vice Chancellor Dr. V.R. Ambedkar National Law University, Sonipat. I welcome today's eminent speaker, Dr. Shalini Ma'am, the former Justice of the Bombay High Court. So we'll definitely be very prejudiced to have a this eminent talk from Justice Shalini Ma'am, and it will be definitely very much informative for our students also. So I welcome ma'am, and now the stage is to you, ma'am. Now the mic is over, ma'am. Now this virtual stage is over to you, ma'am.
Okay, thank you, Mr. Amit, and thank you, Mr. Vikas. It is always a
It's our
pleasure.
pleasure, ma'am. It's our pleasure.
Yes, good evening to each and everyone. It is always a pleasure to interact with those who are interested in the legal subjects, especially our today's topic, as all of us are aware, pertains to the child. The focus of our today's topic is child, and children are not only our future as such, therefore we have to care and protect for them, but otherwise also the children being constituting almost half of the world's population, it is really a matter for all of us, a great concern to look after them, to ensure that they are properly protected and cared for. So far as India is concerned, I mean, it is considered to be having the largest population of young persons. Almost 450 million of our population consist of the children, youngest. So we in that way are is the youngest country. And therefore, the importance of the children in our life, individual life, social life, nation's life, cannot be minimized in any way. And in that aspect, when we consider our constitution, we have to acknowledge that our constitution has really taken cognizance of the concerns of the children and made a special provision under Article 15(3) of the Constitution, which is in Fundamental Rights chapter, to ensure that state is enabled to make special provision or special legislation for children as such. Apart from this fundamental right, Article 15(3), which classify children as a class in themselves, in addition to the women as a class in themselves, considering especially the vulnerabilities of the children, their innocence on account of which at times they may be subjected to evil influences, or at times they may also become the victims of the offenses. We are also having certain directive principles of state policy like Article 39(e) and F, which deals with the rights of the children, especially of the responsibility and duty of the state to provide nutrition, to provide their proper environment for their development. And then we are having Article 45, 47 of the same directive principles of state policy, which also deals with the children and their special rights for the children. Apart from it, we are also having international conventions. The most important convention is Child Rights Convention, which is acceded or adopted by India also, and which ensures that rights of the children are considered as human rights, which are inalienable, intransferable, in every way indefeasible. They are required to be protected. So, international convention, apart from Child Rights Convention, which was brought on in the year 1989 and ratified by India in 1992, or acceded by India in 1992, we are also having the Beijing rules and other provisions, other international instruments which guarantee the right of the children. So far a child is concerned, there cannot be any dispute about the protection of the rights of the children. It may be true that so far as women are concerned, there will be certain disputes, but as regards the children, everyone accepts that children being the innocent class of society, they are required to be protected in every way. Now we come to, apart from the children, if we come to juvenile justice system, the basic tenet of juvenile justice system is that the children being constituting a class in themselves, their rights, they are required to be dealt with differently so as to protect their rights. There is also the concept of criminal justice system as such, that every saint has a past, similarly every criminal has a future, and therefore every criminal, maybe someone who has committed an offense, is required to be brought again in the mainstream so that he can be reformed, reintegrated, and become a responsible citizen or person of the society. So he will enrich the society as such, and apart from that, his rights, individual rights, will be also protected. So one of our theory of punishment sentencing is of reformative theory, and that is of utmost importance in juvenile justice system, because that is the main focus of the entire juvenile justice system. It is not at all concerned with retributive aspect of the punishment, but only of reformative. The third theory, when we are considering about the juvenile justice system, is the basic concept of parens patriam, that is, the state or court as the parent of the child. The underlying philosophy is that if a child has gone astray, it is the parents who had failed. Hence, court has to take over on behalf of the state or on behalf of the parent to diagnose the problem and prescribe the appropriate punishment, treatment, not the punishment. The focus of juvenile justice system is therefore not on what the child had done, but to understand that his or her defined behavior is merely a symptom of the problem, and therefore as a therapist or as a physician we have to resolve the basic issue to solve, and not to punish the behavior. That is the basic concept behind the Juvenile Justice Act. Therefore, the object of the juvenile justice system as such is to promote a holistic approach concerned with the development, care, and protection of child throughout his interaction with justice system. It is expected that child should come in minimum contact with the system, and such contact of the criminal justice system or juvenile justice system should result in positive impact. For that, the system provides an inclusive and enabling environment by reducing the vulnerabilities of the child, that is entire object of the juvenile justice system. Now, if we come to the present Juvenile Justice Act of 2015, we will find that there is some history behind it. Initially, we had long back in the year 1921 act called as Apprenticeship Act, which was dealing with youthful offenders. But that was not at all comprehensive, not sufficient. Then every state started having the Children Act. It was around 1960s. Bombay Children Act was there. Then some central government also enacted the Children Act, which was applicable in some states, some territories, but not everywhere. Moreover, whatever different states were having the Children Act, it was not uniform in definition, neither in regard to the definition of the child, not to the procedure, not to the outcome of the act. And therefore, in the year 1983-86, when Sheila Barse had filed the petition in the Supreme Court, the Supreme Court has directed the central government to enact a uniform law for the children in conflict with law. And at that time, the Beijing rules at that time, Beijing rules were not there. And therefore, in the initial year 1986, first Juvenile Justice Act was enacted. There was different age for different, I mean, for the male child and the female child. For the male child, it was 18 years, whereas for female child, it was 16 years. But then thereafter, the Beijing rules came, then Act 2000 came, which made the uniform age for both the children, male and female, and it was 18. Then we had some amendments in 2006 Act, and ultimately we are having the 2015 Act, which was enacted after a lot of, a lot of public debate, uproar, and sometimes, the main aspect and main force for enacting this Juvenile Justice Act of 2015 was the Nirbhaya case, which everyone knows, which occurred in Delhi, and it was same said that in the gang rape of that victim, the juvenile has played the major role. And therefore, there was lot of demand for reducing the age of the child. Prior to, I mean, child which was 18, it should be reduced to 16. That was the demand. The various litigation, the various cases before the Supreme Court, like Subramaniam Swamy case or thereafter Salil Bali case, this demand was reiterated. Subramaniam Swamy's case was in 2014, Salil Bali's case was in 2013. It was argued before the Supreme Court that the age is required to be reduced considering the current scenario, social conditions where the children are maturing early, and it was pointed out that there is a lot of crimes are committed by the age group of 16 to 18, and therefore it is at most necessary to make the law more deterrent. And then Supreme Court rejected that demand at that time. So it was not those writ petitions were SLPs were not petitions were not successful. Thereafter, even after the Nirbhaya's incident, Justice J.S. Verma's committee was established. That committee was also, had deliberated, considered all the data, and said that there was no reason to reduce the age of child from 18 to 16. So that committee also rejected the said plea. Even ultimately, parliamentary debate, parliamentary standing committee also considered this issue and rejected the said demand. But ultimately, the 2015 Act came to be passed, but we have to remember there are several facets of this act we will be considering during the course of our session. At the outset, it has to be remembered that though certain category of offences were separated by 2015 Act as regards the children in conflict with law, the basic ethos of the juvenile justice system or jurisprudence is not in any way reduced or minimized as such. So when we are considering this Juvenile Justice Act of 2015, I think we can also consider the very basic, key features of the said act. Mr. Vikas, I will be sharing the screen if it is okay.
Yes, ma'am, you can do that.
Okay, I can do that. No? Yes. Okay. So we are having share screen. Yes. Now, whether the screen is seen?
Yes, ma'am.
Okay. So when we consider the basic feature or key features of this act, we can find that this 2015 Act, like earlier legislation, it was more comprehensive, child-centered, child-friendly. That basic concept from 1986 has remained as it is. It is not diluted in any way. And as the preamble of the Act says, it is a complete code to cater the basic interest of the child.
Ma'am, if you click it on the slideshow, then the left side images will not be seen. Just do that.
Okay.
Slideshow.
Okay. Yes, it is.
Yes,
can be
now
seen.
Now it's better.
Yeah. So for now, the Act, that's why I have clarified it. The Act provides for, and it deals with both the juveniles in conflict with law and also children in need of care and protection. Therefore, the Act is, not in single way only, but it deals with both. Now, as I already said, the basic foundations are Article 15.3, which is referred in the preamble of the Act. Then I have also think that important articles from which we can get the basic is Article 23, prohibiting trafficking in human beings and forced labor, Article 24, prohibition of employment of children in hazardous industries, Article 39E, duty of the state to ensure health, 39F, and opportunities and facilities for development, to provide early childhood care and education, to provide nutrition and standard of living. These are the basic foundations. And then, as I said, there are international conventions on which the Act is basically based. Now, when we see the objects and reason of the Act, as usual, it is because in view of the earlier legislation, it says that to consolidate and amend the law relating to children by catering to their basic needs. That is very important as regards protection, development, treatment, reintegration. These are the objects, and therefore all the provisions of the Act so far as regards children in conflict or children in need of care and protection are required to be considered in that aspect only to take further this object. And how to do it? By adopting a child-friendly approach in adjudication. That is entire investigation, trial process and disposal of the matter. So when we are passing the final order, what should be done is a child-friendly approach, and it should be in the best interest of the children, and that is for their ultimate rehabilitation. So the act contains everything which is required to be in the best interest of the child. Now, Act also elaborates certain fundamental principles of juvenile justice, that is Section 3 of the Act, and these principles are of paramount significance. Whenever we are dealing with children in conflict with law, we have to bear in mind that there are presumptions of innocence. I mean, this is available to even adult criminal also. Then there is a dignity and worth as regards children. This presumption becomes double. As regards children, there is also the principle of dignity and worth. I mean, even a child of few months, few days is also having its own dignity and worth. And when the act we are considering the child of up to 18 years, then the best interest of the child, family responsibility, safety, care and protection system, adopt positive measures for well-being, non-stigmatizing semantic, and this is very important because our entire criminal justice system talks of stigmatizing semantics like calling an offender, calling a charge sheet, calling the accused guilty. I mean, all these things, or framing the charge, offense. So everything, this stigmatizing custody, remand, these semantics in our decisions, in our actions, in our language, in our terms, everything is to be avoided as regards the child is concerned. Then there are also non-waiver of rights. That child cannot waive his rights, and no one can consider that child is in a position to waive his rights because that is a statutory mandate. Then equality and non-discrimination, right to privacy and confidentiality, which we will find is very strictly protected. Then important aspect is institutionalization as a last resort. What does it mean? That child should never be kept in institution. Whichever institution may be, family is the best environment for the child to be brought up, and therefore never to keep the child in any special home or even any place of safety. That will be the last resort under the act. And then there is a repatriation and restoration. That is what I always say. Child should be again reintegrated in the society. Fresh start by erasing past records so that disqualification will never come into way of the child in future life. And diversion measures to be adopted without going for judicial proceedings. Then principles of natural justice are also required to be followed. Which are the salient features of the Act? The Act, as I already said, provides separate treatment for children in conflict with law. Who are children in conflict with law? The children who allege to have committed an offense. And those children, second class of children, children in need of care and protection, that is children who are deserted, abused, orphan, beggars, neglected, vulnerable to abuse, etc. So presently in today's session, we are dealing only with the children in conflict with law, that is those children who are alleged to have committed an offense. Their separate forums are also provided for children in conflict with law. There will be a juvenile justice board, which is consisting of the magistrate, judicial magistrate first class, and two social workers, of whom one shall be a woman. Now, this Composition of the JJB board is important because it is considered that an offense committed by a child is not only a legal issue when the court is or JJB is considering it, but it is a socio-legal issue, and therefore the inputs, the contribution, the interaction of the social worker is of utmost importance. This decision of regarding the child needs to be taken not only on legal parameters but on social parameters also. And therefore there has to be one woman, and they are having special qualification, having experience in working with children, having the knowledge of child psychology. These are the various aspects laid down as regards the children in conflict with law is concerned. So for a children in need of care and protection, there is child welfare committee. I mean, that is there, the legal aspect is not there, and therefore the chairperson is not any advocate or judge, but someone different. Whereas children in conflict with law, as the legal aspect has to be considered, there is a judicial magistrate, first class, who is working as principal magistrate, and social workers has to be with him, and a decision has to be taken by majority. But their interaction, their coordination is very important because it is not simply sister a legal issue. I am again highlighting it and emphasizing it because under ordinary criminal law, only the judge will decide only on legal parameters. But juveniles in conflict with law are not considered as offenders or as criminals, and therefore their issues are considered on social backdrop also. Then there is separate police unit to deal with them. That is called Special Juvenile Police Unit of trained and child-friendly police for handling the children in conflict with law. This is a special requirement so far as these children are concerned. If we see the scheme of the act so far as children in conflict with act law is concerned, chapter 1 deals with preliminary and definitions, chapter 2 general principles, which I have already highlighted, that is section 3. Then chapter 3 deals with children in conflict with laws. 7 deals with rehabilitation and reintegration. And chapter 10 deals with miscellaneous provisions dealing with presumptions, appeal, determination of age, etc. And then along with that, we have got the model rules framed in 2016 itself. They are very elaborate, very detailed, and deals with each and every aspect of children in conflict with law. Now, when we are considering the Juvenile Justice Act, first and foremost thing which we have to remember is that it is a beneficial piece of legislation. And for whose benefit? It is for the children in conflict with law. And therefore, all the provisions of the Act which we will find subsequently in the course of case laws are interpreted in such a way that the child in conflict with law stands to be benefited. Then it recognizes, as I said, that it is a socio-legal economic issue, offense. Another thing which is also of importance to remember is that Act does not do away with the enforcement of the law. I mean, for the children also, the same law, IPC or other law applies to children, even in these children also. Now, under IPC, we all know that there is a presumption of innocence as regards child up to the age of 7 years, and thereafter up to the under section 82 up to 7 years, and thereafter under section 83 from 7 to 12 years, unless the child is shown to be having the maturity to understand the nature and consequences of the act, he will not be called as an offender. So same IPC, the same law of general exception applies here also to the children. So mostly when we are considering with JJ Act, we are dealing with the children who are in between the age of mostly 12 to 18 or at the most above 7 to 18. Rarely, I mean, 7 till 7, they are not coming in the system at all because they are coming under general exception in IPC. So what I want to emphasize again is that children are held accountable. It is not that they are given total immunity under the JJ Act. What JJ Act contemplates is a different treatment, a child-friendly manner, a different outcome, and not the same outcome like an ordinary criminal or ordinary criminal system. So for any offense alleged to be committed by the child, he is accountable, he is liable, but he is, being a child, a different treatment and different outcome is provided to him. So different scheme for trial, inquiry and disposition. And we have to remember, as I said, non-stigmatic, and therefore we have to consider that it is not a trial under the act, but it is always an inquiry. Trial necessarily contemplates that you have to apply all the legal principles, whether offense is proved beyond doubt, then evidence act. So it is very much made clear that it is an inquiry, and therefore it cannot be adversarial. Here everyone is coming together and finding out a solution to the problem. Then we have to remember certain, terms also, semantics also. That child in conflict with law is not to be arrested. I mean, Act has dealt with all these aspects very well. So arrest necessarily implies some criminality. So he is to be apprehended, not a charge to be framed, not a conviction, judgment of conviction, guilt, etc. So emphasis of inquiry is not only to find out the innocence of whether child is innocent or otherwise, but also to investigate the underlying social causes. So only when we know about it, then you can suggest the solution to remove those social causes so that child can be reformed and rehabilitated. And therefore the inquiry and post-inquiry avenues have to be kept open for the child. What is the duty of JJB in such scenario? Not to blame the child, not to determine the guilt also. What is the focus? But to identify the underlying problem. Because at the heart of JJ system, it is the construction of the childhood, and because children are considered as immature both mentally and socially. Hence, Section 8 of the Act, which deals with inquiry, how it is to be conducted, it mandates that it should be done, it should be fair, it should be speedy, and it should be done. It is done in the spirit and object of the Act. And we have already seen what is the spirit and object of the Act, child-friendly manner to protect the best interest of the child. There are three important R's which are necessary to be borne in mind, that is reformation, rehabilitation, and reintegration of the child, which is really the object of the JJ system and which is really the object of Section 8 of the Act also, which deals with the inquiry aspect. As I already said, who is child? That is again an important issue, and definitions makes it clear that person who has not completed the age 18 years of age. Therefore, now it is a uniform age for both male and female child, and to 13 who is alleged or found to have committed an offense and who has not completed the age of 18 years. Now, which is the decisive date to determine whether he is a child or not, and it is the date of commission of the offense. Child might have been apprehended at the age of 30 also, but if he has committed the offense when he was below the age of 18 years, he will be still considered as a child in conflict with law. Earlier, there was a lot of confusion, and therefore now the Act has made it clear. Judicial decisions have already also made it clear earlier in Pratap Singh and other judgments that it is the date of commission of the offense which is of paramount importance, and not when the accused is apprehended or not when the child is tried or inquiry is held. Then, as I said, there are separate homes provided under the Act. One is observation home where child is to be kept during inquiry. And another is special home where child who is found to have committed an offense is to be kept after inquiry as per the order. And their rehabilitative services are to be provided to the child. My friends, here again remember that observation home and special home. Act doesn't use the word remand home. Act doesn't say jail, Act doesn't say prison, Act doesn't say any other home. And it is very important. Still now, sometimes, we use the word remand home. Even the law advocates, and those working in the system also. Remand home connotes some criminality in the sense that the child who is, he is remanded, and therefore Act says no. Observation, you are observing during the inquiry. how the child is performing. Special home, after that inquiry if he is found to have committed the offense. And there also, it is not as a sort of punishment, but it is for rehabilitative services, to provide him counseling, to provide him psychological support, to provide him education, then development of skill. So these are the only two homes. And the third is place of safety. And that is not to be a special home, observation home, not a police station, not a jail, but totally a separate premises, which is to be established separately, where child can be kept both during and after inquiry, but it is as per the order of the JJB. And it is mostly when the child is above the age of 18 years or above the 17 years, if it is found that he is required to be placed in view of section 15 of the Act now. So never use the word remand home, because Act doesn't say so, and it is for right reasons. So these are the three places where the children can be kept. Like three places, there are also three kinds of offences which the Act recognizes. One is petty offences, for which the maximum punishment is 3 years imprisonment. No question about it. Then serious offences, for which punishment is imprisonment between 3 to 7 years. And lastly, the heinous offences, for which minimum punishment is imprisonment for 7 years or more. And this definition of heinous offences has really created a lot of confusion. And then we have latest judgment of the Supreme Court in which that confusion is tried to be resolved. So as regards IPC, we know that there is no such concept of serious offences, heinous offences, but JJ Act recognizes it, and that is done for the first time in 2015. Because we know that CRPC, IPC only talks of cognizable offences, non-cognizable, bailable offences, non-bailable offences. There is no question of serious offense. But now this Act has categorization, has made categorization, and it was also subject to lot of critique, lot of, uproar about it. And because this definition of heinous offenses was leaving about 46 to 55 offenses in the IPC itself out of the purview. And therefore, the Supreme Court has to interpret it, and that we will be considered in the judgment of Shilpa. For the time being, we have to remember that this Act recognizes three offenses. Then there are certain prohibitions under the Act, and they are to be strictly followed. One is Act prohibits use of handcuffs, chain, fetters, naturally, because child cannot be arrested, so no question of use of these. Then immediately on apprehension of the child, information is to be given to the parent, guardian, and probation officer. In the entire scheme of the Act, probation officer plays a very pivotal role, because it is he who prepares social investigation report about the conditions of the child and other aspects. So his report is of evidentiary value also. Then it contemplates that immediately after apprehension, child is to be handed over to the special juvenile police unit. As I said, that is a separate cadre. And in petty offences, police can dispose of the case at police station itself. So they need not even register the FIR. If it is not a petty offence, that is, if it is an offence punishable with imprisonment above 3 years, then child to be produced before JJB within 24 hours. Then the rights of the child in conflict with law, as I said, not to be arrested but apprehended. And it is to be done by plainclothes police and not in uniform. Not to be handcuffed, not to be coerced, forced to give statement. Then to have its parents promptly and directly inform about the apprehension, to get appropriate medical assistance and legal assistance, then to get assistance of interpreter, educator, or any other assistance. Sometimes, children of other states who do not know the language of this state may be found in this state. And if they have alleged to have committed the offense, to make inquiry with them, to know what is their case contention, the assistance of such interpreter, or in case of mentally or physically disabled children, educator, may be necessary. Child is not to be compelled to sign any statement, not to be sent to police lockup, custody, or jail custody. Then probation officer, as I said, this is the right of the child to be informed immediately. and to be produced immediately before the JJB. Now, how these procedures are to be conducted, that is what is important. And Section 8 provides that it should be in a child-friendly manner. And Act doesn't stop merely saying that it should be a child-friendly manner. But Section 8 and Rule 6 and other rules specify how it should be. Now, Rule 6 specify that while communicating with the child, the JJB should use the child-friendly techniques, adopt a child-friendly attitude, not only in the language, but body language, facial expression, eye contact, volume of voice. I mean, when we talk with the child in the same way, we have to talk with the juvenile child in conflict with law. Then to put the child at ease, to encourage him to state the facts and circumstances without any fear, in respect of all. I mean, it is very important that we are not making inquiry with the offender as such, but we are making inquiry with, like in the school, the teacher is making inquiry with the child who has done something against the discipline. So that is how the JJB has to conduct itself. And then Section 215 also defines what is child friendly means. And it means any conduct, practice, process, attitude, environment, treatment that is human. So we have to know that entire JJ system is an attempt to humanize the criminal justice system so far as children are concerned. And therefore the child friendly manual has to be considerate in the best interest of the child. Then sitting arrangement also, I mean, POSCO Act also does not elaborate it so much, like Protection of Children from Sexual Offences Act, which is of 2013, also does not elaborate 2012, but JJ Act elaborates how the sitting arrangement should be. So it should not look like courtroom. Arrangement should be such to enable the board have the contact with child face to face. Board shall not sit on the raised platform. There will not be barriers such as witness box, bar between the board and the child. Venue should not be intimidating to the child. It should not resemble as regular court. And it should, the premises where the JJB should sit is a observation home or a place in proximity to observation home or at a suitable premises. The venue, as I said, not to be intimidating. It should not be like regular court. Other criteria, other guidelines, other directions which are that child's informed participation should be sought at each step. I mean, what the child feels about it, what child wants to communicate, what child has to say. Like in regular criminal trial, we rarely ask the accused. At the end, only we record his statement under Section 313 CRPC. But here, that is not the case. Since the day one, every child's wishes, child's desires, child's opinions are taken into consideration. And the duties cast on the JJB to ensure that his rights are complied with or ensured throughout the process. Inquiry to be completed within time bound, have the individual care plan followed by the probation officer, and then the various rights of the child are also laid down further in Section 99, right to confidentiality, the record of the child, the report relating to the child are not in any way to be displayed on the website, not in any way its certified copy to be given, not in any way to be available to others for perusal. A right to privacy, no other third person can be present during the course of inquiry. Inquiry to be conducted in simple and child-friendly atmosphere. I mean, it is repeated and repeated several times. And in case of petty offences, if the police have not disposed of, then it is for the board to do so, to dispose of it in a summary manner. Then there are certain presumptions and determination of the age. The issue relating to age is always a really, sort of giving lot of rise to the case laws, to legal issues, because in India we find that the birth of the children is very not registered every time. And therefore, as regards the registration certificate, birth registration certificate, it is not available in majority of the children. And then how to determine the age, because age is going to make a lot of difference. Even a 1 day difference is less by 1 day to the 18 years, he is entitled to all the benefits of JJ system. And therefore every attempt is made on the part of the child to show that he is below the age of 18 years, whereas every attempt is made on behalf of the prosecution to show that he is above 18 years. In the absence of then the concrete opinion, I mean concrete birth certificate, what can be done? This presumption laid down is that when the child is produced, he is presumed to be below 18 years of age. That is what section 94 says. And so on the basis of physical appearance, one can come to the conclusion. If there are reasonable grounds, then only the evidence relating to his date of birth certificate, date of birth from the certificate from school or matriculation certificate. If it is not, I mean school certificate, school living certificate, matriculation certificate is not available, then the birth certificate by corporation or municipal authority or a panchayat, and only in absence of all the three, the medical age determination test. Because it is an acknowledged fact legally also that ossification test which determines the age is not accurate. It only gives approximate age like between 15 to 17, 16 to 18, and then the benefit of marginal doubt, marginal difference in age. So 1 year, 2 year, lot of case law was on there, and therefore this medical age determination test is to be applied only when none of the above document is there and there is a reasonable ground. Then we are having right of bail, which is of importance as regards CICL, because here the considerations for bail are totally different than the considerations which apply as regards the adult criminals. In respect of adult criminals, we know that if the offense is serious, if there is likelihood of tampering of the witnesses, of his absconding, then we deny the bail. But here, the accused, as of right, is entitled to bail. Only three exceptions are provided, and they are also in his best interest. When his release is likely to bring him in association with any known criminal, or expose him to moral or physical or psychological danger, or his release would defeat the ends of justice. So, whenever the court is rejecting the bail, the court has to bring the reasons in any of these criteria. Otherwise, in 99% cases, I mean, as of right, in 100% cases, the accused is to be released on, child is to be released on bail. Only when it is not in his interest, then only his application can be rejected. And fortunately, we have got the latest judgment of Delhi High Court on this aspect. I mean, that is 19th October 2020. I mean, it was just yesterday I found reported on some law forum, law platform like a bar and bench, wherein it was held that a bail plea filed on behalf of the juvenile can be considered and only be considered on the criteria laid down in Section 12 of the JJ Act. The considerations for denial of bail are to be in the best interest and welfare of the child and not the aspects to be considered under Section 439 of CRPC. So now it is very well clear. Otherwise, also Section 12 was very well clear that no other criteria can apply which ordinarily apply under 439. So if it is in the detrimental to his interest, then only you can deny the bail, otherwise not. There is also one aspect that if the child is in the age group of 16 to 18 and if his case is already committed to the children's court, whether such child is also entitled to bail as of right. This aspect is also clarified by Delhi High Court. It was held that even when a child is sent up for a trial as an adult in children's court, the child does not de jure as a automatically become a major, but is only to be treated differently as regards heinous nature of the offense. But otherwise, there would not have been separate children's court to try him with specific safeguards. So even as regards the children between 16 to 18 who have alleged to have committed the heinous offense and their case is transferred to children court, they are also entitled as of right to bail, except for these three exceptions. Because that child also does not de jure become a major, which is very important. Then there are certain further prohibitions. In no case, as we have already considered, if the child is not released on bail, then what is to be done? Then, as I said, he has to be sent to the observation home and not to any jail or custody. As regards inquiry, it is to be remembered that it has to be completed within 4 months. If it is not completed, then for the recording reasons, getting permission from the CJ, 2 months period can be extended, but 6 months. In case of petty offences, it is, as already said, summary trial. In case of serious offences, as a summons trial. What is the nature of the inquiry? Fact finding. And therefore, the JJB has to use the power under Section 165U of Evidence Act. And we know how wide those powers are. Relevant, irrelevant, totally not considered. But JJB can make any inquiry under Section 165U of Evidence Act. Again, I am saying in petty offense 6 month maximum. If inconclusive, then proceedings to stand terminated. So such a wide, thing is considered. Now we will come to section 15 of the act, which is of, as I said, there is lot of debate on this aspect, and it was brought on record after Nirbhaya incident. And as they say, sometimes, the people who oppose, academicians, scholars, jurists, they were saying that hard cases make bad law, and this is section 15 is one of it. Because what it says is that children between 16 to 18 years, JJB has to conduct, and if they have committed the heinous offense, that is above 7 year imprisonment, then the JJB has to conduct preliminary assessment. What is the preliminary assessment? It is in respect to his mental and physical capacity to commit such offense, ability to understand consequences of offense, and the circumstances in which he allegedly committed an offense. So JJB has to consider all these four factors to arrive at the decision whether his case is to be tried by JJB itself or it should be sent to the children's court. And JJB has to record a reasoned order. So JJB in such situation can take assistance of experienced psychologists or psychosocial workers or other experts. So these are four important criteria which the JJB has to apply when the child is in between 16 to 18, above 16 and below 18, and he has committed an heinous offense. Now, Bombay High Court has, in the judgment of Mumtaz Ahmed, has stated that all these four aspects, that is physical capacity, mental ability, understanding, and the circumstances in which the offense are committed, are indispensable. They must be present together, and one is present, other is not present, will not serve the purpose. It was held that let us remand ourselves just because the statutes had said that child above 16 years and beyond can stand trial for the offense as an adult, it does not mean that legislature intends that all those children should be subjected to adult punishment. So sending the child to the children court as an adult is not a default choice, but it is a conscious, calibrated one. And for that, all the statutory criteria must be fulfilled. So it is very important for the JJB while passing the order to ensure that these four criteria are very much satisfied, because in this case, Mumtaz Ahmed Nazir Khan's case, facts were very interesting and you should read it. The child, there were two youthful offenders. They had committed, alleged to have committed the murder of a small girl. There was report of probation officer, and it was not disclosing anything. The orders were also not of that, satisfying all these criteria, and therefore the preliminary assessment was not considered to be done properly, and the commission transfer of the case was held to be not proper. Then we are having the latest judgment of Shilpa, 9th January 2020 judgment of Supreme Court in the case of Shilpa Mittal. As I said, what is heinous offense? That was lot of confusion about it. And therefore, whether offense prescribing a maximum sentence of more than 7 years imprisonment, but not providing any minimum punishment, what will be, whether it will be a heinous offense. And the Supreme Court has, as I said, considering the object of the act, that is beneficial legislation for children, held that an offense which does not provide minimum sentence of 7 years cannot be treated as a heinous offense. So there has to be specifically a fact that it is a minimum sentence of 7 years. So offense where the maximum sentence is more than 7 years imprisonment, but no minimum sentence or minimum sentence of less than 7 years is provided, shall be treated as a serious offense till the parliament takes the call. Because what happens in that case, what has happened, the offense which was committed by Shilpa was of 304 IPC, that is culpable homicide not amounting to murder. There the punishment may extend up to 10 years, but it does not provide minimum punishment of 7 years. That is the case in respect of offense of robbery, also 392, and several such offenses like attempt to commit murder, also 307. Bombay court has held that there is no requirement of minimum sentence in these offenses because they said exceeding up to 10 years. And taking all those cases in contemplation, the Supreme Court has now made the things very clear that where the minimum sentence of 7 years is not provided, then it would be a serious offense and not the heinous offense. So that angle is now made very clear by the Supreme Court. Now coming to preliminary assessment, it has to be completed within 3 months. Order passed is appealable if JJB is after holding this inquiry, and it is not a trial, assessment is only an inquiry. So after holding this assessment, if the JJB is of the opinion that there is need for child to be tried as an adult, then transfer the case to the children's court. Otherwise, JJB to decide the same following summons trial procedure. Now, what is the children's court to do? The children's court has to again decide. I mean, the JJB's decision about preliminary assessment is not final. It is subject to again, assessment by the children's court. That is a session court, special court under POSCO Act or wherever the children court is established. It has to consider whether there is need for trial of the child as an adult. If yes, conduct such trial considering the interest of the child, tenets of fair trial, maintain friendly atmosphere. So all those safeguards which were available to the child under JJB are again available in children's court also. Thereafter, if the child is found to be guilty, then child can be sent to the place of safety, as I said, which is not a observation home, which is not a special home, but a separate establishment till the child attains 20 or 21 years of age, and thereafter, again to take call, again to consider whether child should be released or sent to the jail. There, your total bar is not to send such child also to death or life imprisonment. If there is no need to conduct trial as an adult, then the children court can conduct the inquiry itself or pass it to the JJB for further inquiry. Then the children's court and everyone JJB has to include individual care plan for the child in its final disposal order. If it is sent to the place of safety, then child has to be provided rehabilitative services, then call for periodic follow-up report, ensure that there is no ill treatment. On completion of 20 years, may child release the child under supervision of monitoring authority or order the child to complete remainder of this term in the jail. Now, so far as JJB is concerned, which final orders JJB can pass? Advice or admonition. I mean, that's why, depending upon the nature of the offense, depending upon the age of the child, depending upon the circumstances. So when the JJB is considering the case, JJB is disposing of the case, then advice or admonition, counseling to child and parents, group counseling and similar activities, community service under supervision, fine if the child is above 14 years or the parents, then, however, no default punishment, release on probation under care of parent, fit personality. Then either sent to special home for maximum period of 3 years till the child attain. In addition to direction to attend the school, vocational training, therapeutic center, etc., etc. Transfer child to CWC, not to be sentenced again. All final orders are to consider necessary include an individual care plan. There are certain further safeguards which like principle of fresh start, then no disclosure of identity, reports to be treated confidential, all past records to be erase, presence of the child can be dispensed with in inquiry, no stigma, removal of disqualification, record to be kept confidential, no joint proceeding with adult accused. Moreover, if in inquiry it is found that child is actually in need of care and protection, though the child is stated to be have committed an offense, then the JJB can transfer the child to CWC to be treated as child in need of care and protection. Then the rehabilitation and reintegration by various modes which can be considered by the CWC in its own way, like adoption, then foster care, sponsorship, etc. Conclusion, we can say that so far a child is concerned, we have to remember the poem by Gabriel Mistral. There is a video also. Right is the time his bones are being formed, his blood is being made, his senses are being developed. To him we cannot answer tomorrow. His name is today, and therefore whatever measures safeguard we want to take as regards the child, they are to be taken now and immediately. And then it is said that so far a child is concerned, I mean, to bring up a child, there is a proverb in Africa that to bring up a child, entire village is required. And therefore, it is the everyone has to consider as regards the child is concerned. Everyone has to contribute for the child. Uh,
The insights have been given very lucidly. Meanwhile, we have a question by CSG. A child requires a healthy atmosphere and family to grow up. Prima facie, there is no legal definition of family and family rights which are actually implemented by the implementing agencies. No. Next question would be.
yes, question.
Ma'am, I'm taking the question.
Yes.
Can
Yes.
children in conflict with law file anticipatory bails in a case?
There is no need of filing anticipatory bail as such because child is not to be arrested. When the necessity of anticipatory bail will arise when child is to be arrested. Here the child is apprehended, not to be remanded to any custody, not to be remanded to any police custody or magisterial custody. He is to be kept in observation home only and nothing more than that. Moreover, he is entitled to be released as of right on bail, except for these three conditions, exceptions. So, as regards criminal procedure code, it is not applicable because it is a special legislation. Criminal procedure code is a general legislation, and therefore the anticipatory bail provisions are not applicable and not necessary also in the first place.
This is by Ritesh Upadhyay. He says nowadays, since children are also creating heinous crimes like rape, etc., even though they are in the early age of 16, but they are mature enough to know the nature and consequence of the act. As in the era of internet and social media, they are exposed to anything, everything. So the maturity level is far higher. What is the difference between the criminal child and the other criminal? So don't you think some exceptions are required to be carved out for such children?
That's why I said, Juvenile Justice Act, Section 15 has now carved out that exception. Now, what it has done, that if on preliminary assessment it is found that child has attained sufficient physical maturity, mental ability, and the circumstances in which the child has committed the offense, the child is also able to understand the consequences of the act. So, on the basis of this preliminary assessment, if it is found that really the child has committed the offense, with full understanding, with full maturity, knowing the consequences and also the circumstances are such that we cannot call him as a child, then definitely he is to be his case is to be conducted like an adult by the children courts. And definitely the children court can, on the basis of the offense, send him to imprisonment also after he completes 21 years of age. But not to death or life imprisonment, having regard to the tender age, adolescent age, because it is considered that physically child may have, I mean, there is no criteria, basic objective criteria to decide at which age or at which point in your life you attain the criminality element, criminal element. That is really criminal age, one may call it. I mean, innocent age up to 7, in between 7 to 12, 12 to 18. But really, after, I mean, child who is one day below also, whether he is really, I mean, has not attained the criminal age, child who has is one day more than 18 years, whether he has attained, I mean, there is no fixed straight jacket, iron way of saying that this is the age on which you attain criminal elements, with criminality, you attain the criminality. And therefore, now via media is found out. The definition of the child, in the definition of the child in JJ Act also, it is said 18 years. But if it is found that he has, committed the heinous offense and he is in between the 16 to 18 bracket, then he will be assessed independently to on all these four criteria, and thereafter only he will be tried as an adult. So it is not that all the children are now given immunity. It is not that all the children are saved. As I already said, the children are not spared from not spared from the consequences of their act. They are liable, like, for all the outcomes. IPC is applicable, CRP is applicable to them. So merely because he is a child, he is not accountable to that? No, that is not the case. He is equally accountable. The only thing JJ Act provides is to deal with him differently, to pass different orders as regards these children. But as you have rightly said, having regard to Nirbhaya's case and having regard to the current situation where the children, are early exposed, where the maybe due to earlier due to TV, then internet, thereafter, social media. So maybe this bracket was, said that if they have committed these heinous offenses, now in the definition of heinous offenses, very few offenses will come, as explained by the Supreme Court. Now there will be only rape, murder, or terrorism, where the minimum punishment is 7 years, not less than 7 years. I would like to, in this respect, quote the extract of the judgment of the Supreme Court. Justice Naidu has very elaborately in this judgment of Mumtaz said that initially a TV, then internet, now post-truth social media have led the children, especially adolescents, leapfrog, frog, into adult world. Mostly it is a crash landing with disastrous consequences. So childhood innocence has become a casualty. And therefore now we are making them separate cadre of offense, a separate category of, offenders, or in conflict, children in conflict with law, and we are treating them differently, taking into consideration the current scenario. Especially this situation arises in POSCO cases majority of the time, when both the boy and the girl are in love relationship, they elope, then girl is always considered as a victim and the boy becomes an child in conflict with law, because there also the age of consent is reduced from enhanced from 16 to 18, and therefore consensual sex also becomes, makes the child, male child, an offender, whereas female child a victim. And in such situation, sometimes the age also criteria also is important, where the juvenile system becomes essential for as regards these children also. But as regards heinous offences, the legislation has now made the provision, necessary provision to send their cases to the adult system, children's court.
This question is, sometimes the adult criminals force children to commit offense, or children get involved in false allegation. Then what is the way forward?
Yeah, that's why, JJB has to consider not only, the age of the child, not only the nature of the offense, but the circumstances in which he has committed, circumstances in which the act occurred, and his understanding. If it is, and therefore social workers, the magistrate make in-depth inquiry with the child. It is not like criminal trial, it is an inquiry. As I said, school teacher makes inquiry, why you behave like this. Similarly, JJB makes inquiry with the child, whether he was really forced, whether he was coerced into this business like drug trafficking, drug peddler. They use the children. In such situation, the child is weaned away. I mean, child is not considered as an offender, but child is sent to reformative services. Child is given developmental skill, education, so that child is brought under the JJ system and he is given the community services. So he is not punished, sent to jail, sent to imprisonment in any way. Considering the circumstances of the offense, appropriate disposition order is passed, like releasing him on probation, giving him the warning, giving him admonition. So, child's circumstances in which the offense has taken place are rightly considered by the JJB, which consists of social workers, and thereafter the appropriate disposition order is passed. So, if the child is forced, he will not be subjected to sentence. He will not be sent to any, even special home also. If it is brought before the JJB that it was a coerced act.
Ma'am, we have taken all the questions.
Yes.
I will request the worthy Vice Chancellor, Professor Dr. Vinay Kapoor Mehra, to propose the vote of thanks. Before I do that, on behalf of the Beyond Law CLC team and the Dr. B.R. Ambedkar University, we are quite thankful that your insights, as usual, were spot on, and we are quite sure that it's a topic which has taken up a different dimension with the flux of time, as you have elaborated the journey of law as such, we can say, the vast journey from the around centuries of the act you have proposed. But before I ask ma'am, tomorrow's session would be on emotional intelligence skills for success and way forward. This is by Manjula Thakur. She's a Josh Talk speaker and a life skill coach. So do stay connected with us at 4 p.m. tomorrow. And over to you, ma'am, Dr. Professor Vinay Kapoor Mehra, the Vice Chancellor of Dr. B.R. Ambedkar National Law
Yes, good
University.
evening, everyone. So I'm very delighted to have the views from ma'am. And I think our students have been much motivated not only by your talk, but by the presence, your own presence. So that is very, very encouraging for our students, especially the girl students. And I was reading your biodata and how you have made your journey with the hard work and sincerity and whatnot. So I'm really appreciable that means that your hard work is really encouraging. So my experience with JJB as a member for 2 terms, so which I would like to share here is that there is lack of infrastructure. Most of the time the PP was not present and there was adjournment. Many a time the principal magistrate was so occupied with the other case laws, dependency was too much that the least time was given to the JJ cases. And in most of the JJBs, the trial is in itself the court. The only difference is the magistrate is not sitting on the dais and coming on the chair. So there was not a separate, and I repeatedly wrote to the government and to the CWC that we are not practically implementing the act. The act is so good, you have narrated very elaborately that the whole purpose is to reform the child. But when he is brought to the same environment, how we can reform him? So there is need for the proper implementation, for the proper, even there is need for the training to the members. So those who are not from the law background, they don't have much, and mostly they are not attending the all those proceedings. So hardly they are just appointed as a member, and then they say, "We are appointed," and that's all. So unless and until we work sincerely, we cannot find the real achievement which is to be provided by this act. So anyhow, we all have to work for it. So as a citizen, as a teachers, so one thing is there that there are certain lacunas in the act itself. Because when there is a repeater and we say that there should not be any record background of the child, so every case is tried afresh. In those cases, I think there should be something to be done. When the child has this much maturity that he is repeating the same offense, then he should not be given any leniency, because the purpose is to improve and he is not improving at all. So the whole purpose is gone. So with this word, I again thanks the whole team of Beyond Law, my students, my teachers, and the audience present here for this joint venture. Thank you, everyone.
Thank you so much to Vikas and ma'am, Vice Chancellor ma'am also. And there are always in, social beneficial legislation, there are gaps, sometimes implementation gaps, sometimes infrastructure gap. But with legislation is concerned, it is there in place. Now we have to implement it, and that depends upon our lawyers, our law students, how they implement it in future. So a onerous duty or liability lies on the law schools also. But anyway, thank you so much for this opportunity, Vikas. Mr. Vikas, thanks so much. Thank you to all the participants and wishing you all very best. Thanks a lot.
Thank you, ma'am. As usual, what I said, that the insights are always insightful from your side. And as we say that the law is also a continuous evolving process. Whatever we learn, that is why the judgments keep on changing on the ground, not simplicity changing. It changes with the flux of time as the society changes. So thank you to everyone, those who have stayed connected with us on the Facebook, Instagram, and the YouTube, as well as on this platform. And so do stay connected with us tomorrow at 4 p.m. Everyone stay safe, stay blessed. Namaskar and enjoy your Sunday. We have already had a food for thought.
Enjoy your Sunday. Enjoy your